Hello, everyone, and welcome to our webinar today called Real Property, Real Planning, Planning for the Property that You Own. Today, it's going to be me and Luna Hernandez talking about different aspects of your real property and some issues related to it that you might not be aware of. As you're aware, our firm does estate planning, probate, trust administration, as well as business law that includes entity formation, employment law, mergers and acquisitions. I like to say basically everything for the employer. We want to protect you. So as you're aware, I'm Paula Clarkson. I'm one of the partners here at Merhab Robinson Clarkson and head of the estate planning department.
Thanks, Paula. And my name is Luna, and I am an associate attorney in the business department and have been with the firm for close on 5 years now.
Okay. So let's go ahead and get started. One of the questions that we come up with a lot of times is, what is real property? Ways to hold real property, tax issues associated with that, and then how do we transfer the real property at death without causing any issues? So to get started, what is your real property? We call real property anything that has to do with basically real estate. Your home, your residence, your second home if you have a vacation property in the mountains or at the beach, a rental property that you may own, a second home that you rent out or do a vacation rental on, raw land that you have. You'd be surprised how many of our clients have raw land out by Bakersfield and Apple Valley and different things, as well as any commercial property that you may own or have an interest in. So anything that's connected to the ground versus tangible personal property, which is going to be your things like your car and jewelry and so forth. So today we're only talking about things that are dealing with real estate. So there's multiple ways that you can hold title to real estate. And this gets kind of tricky depending on what your goals are. And each one has obviously significant factors. So holding title as a single person could be just, Jane Doe, she's a married woman, is her sole and separate property, because you can hold property as separate property if you're married, or just, like Charlie Brown, a single man, if he bought the house before he was married. A lot of couples will hold property as joint tenancy. This could be Jane Doe and Charlie Brown, husband and wife as joint tenants. It could also be between people who are not married, like Jane Doe, Charlie Brown, and Fred Smith as joint tenants. So you can have multiple users. And we're going to go into detail more about what each of these different type of titles means. California being a community property state, we can also hold title as community property with right of survivorship. This is a special type of way to hold title only for married couples. And the way you see that is Jane Doe and Charlie Brown, community property with right of survivorship. A lot of people will hold property in an LLC, and Luna will go into detail in a little bit why that's good. And you would have the name of the LLC, Acme LLC. And then trust, we would like you to put your property in a trust so you can avoid probate, and you would deed the property. For example, Charlie Brown, a single man, or Jane Doe, a single woman, to Jane Doe, trustee of the Jane Doe Trust. And that is now how your asset is held in the trust. You can also have multiple trustees like Jane Doe and Charlie Brown, trustees of the Brown Family Trust. It could be husband and wife, or it could be Jane and her son that are co-trustees, or Jane and a friend that are co-trustees. Being a trustee does not mean that you own the property. It means that you manage the property.
And just jumping in there, Paula, on the last point about the LLC and the trust holding the real property, sometimes we see clients that have formed LLCs for the purpose of holding their real property, and then they have questions about, oh, is it in my trust though? What this question really begs is, how are my ownership interests in my LLC vested? So the property can be in the LLC, but then the ownership interests of the LLC can still be in your trust. So just a distinction there.
Yes, it's different layers for them. So joint tenancy, a lot of people will use joint tenancy, especially on their residences, but there's some pitfalls with it. And We're concerned about that for joint tenancy, as it does not avoid probate or possible issues if someone is incapacitated. So when you have a joint tenancy, so let's say, for example, Luna and I hold a piece of property as joint tenant. If I pass away, Luna then becomes automatically the sole owner of the property without going through probate, which is a very good thing. But the downside is, what if I had Alzheimer's and Luna wanted to sell the property or needed to get a mortgage on the property? She can't do that if I'm incapacitated and she doesn't have control, or somebody else does not have control to make my financial decisions. So it often puts people in a place, especially spouses, that if one is incapacitated, the other one cannot make those decisions, and they will have to go to court and get a conservatorship of the estate over the other person. So that, while it helps at death, it does not necessarily help for incapacity planning. Also, if, for example, I own 50% of the property with Luna and I die, she gets it. My family does not get any benefit to this property. It is now owned 100% by Luna, and she can do whatever she wants. So my spouse, my children cannot come and say, Luna, I want some of that, because they don't have any right to it anymore. And that happens a lot when we have married couples with second families, that they may inadvertently transfer it to the other person. Also, we have an issue that when someone passes away, we get a basis adjustment in their property. Basis is generally the value of your property plus any improvements. And basis is necessary to determine any capital gains tax that you may have on the property. So when we die, so if I buy a property for $200,000, that is my basis. And then if I die and it's worth $1 million, then my basis gets adjusted from 200,000 to $1 million. So that means that if my heirs were to sell that property, then it would be sales price minus the basis on my date of death, the $1 million, would determine their capital gains tax. When you're dealing with joint tenancy, only the decedent's half of the property gets a basis adjustment. So going back to my example of Luna and I owning a piece of property together, if we buy it for 200,000, my basis is 100, Luna's basis is 100. If I die, my basis gets adjusted, but I only own 50% of the property. So my basis gets adjusted to 500,000. Luna still has her 100,000 of basis. And if the property is valued at $1 million and she sells it, she's still going to be subject to capital gains tax on the $400,000 difference. Now, that's not something you can get around when you have friends owning the property. When you have spouses, there's ways to get around it, and that could be a real downside for married couples. So that's why we like community property with right of survivorship for married couples, because when you have community property, it does not matter which spouse dies first. The 100% of the property gets a basis adjustment. So all of our clients, when they take title to a new home, if it's not put in their trust, we recommend at least community property with right of survivorship. But you still have, while you have the benefits of the basis adjustment, you don't have any of those benefits, or you still have some of the same pitfalls that you have on the joint tenancy, meaning that if my spouse and I own community property as community property, and he becomes incapacitated without a power of attorney or it potentially being in a trust, I do not have any power to get a mortgage on it, to sell it, to lease it. I would still have to go to court. So it's a bit better than joint tenancy, but not quite all the way there to avoid court intervention upon incapacity or death.
And this is where I'm going to jump in. Another way to hold real property is in a LLC, so a limited liability company. The main pro here, I always say, is asset protection. There really is limited liability for matters related to the property, meaning if someone comes onto your rental property, let's say, and slips and falls, it is essentially the LLC that needs to be sued as the owner of that property. It also allows for centralized control of the property, especially if there are multiple owners, meaning you would have an operating agreement that sets the rights and the obligations of the various owners of that property, and terms such as what happens if one of those members dies or becomes incapacitated. What happens to that particular interest in the LLC in that event? Paula is best suited to speak to any discount valuations on death.
Yeah. So what happens when anybody dies, you have to value all of your assets at death. So it goes back to if I own a property with Luna and we put it into an LLC, then I only own 50% of that LLC. So when I die, my value of that asset needs to be included in my estate, and I get to determine if I owe estate taxes. Because I only own 50%, we can discount that valuation because there's a little bit of lack of marketability, maybe lack of control. Even worse if I only own 20% of it or 30%. Because if we have $1 million property in an LLC and I only own 20%, it's probably going to be very difficult for me to sell that on the open market for $200,000 because I don't have any control over the property. I have some, lack of control with voting, or if it's sold, or if there's mortgages or different things like that. So when we value the property, we can take discounts, sometimes 15, 20, 30%, depending on the situation. And that can be very important if you're in a position that you owe estate tax. Getting discounts on, $1 million isn't a huge amount, but still, even if a lot of people will have commercial properties that might be $15,000, $20,000 or $20 million, getting a 15% discount, 20% discount on your ownership could significantly help your heirs with regard to the estate taxes.
Another pro is really the privacy that an LLC offers. And I will say that is not a privacy that is completely private, because you still have to have a manager of the LLC, and that person's name will be listed on the Secretary of State's statement of information that you'll have to file. That being said, on that statement of information, you do not need to disclose who the owners of the LLC are. So it's really just who your managers, and sometimes those are the members. So if privacy is a concern to you, I would say that your LLC is probably a good way to go. There are, of course, downsides to having an LLC. There is the initial setup of an LLC, which can, with our firm, cost between $2,500 to $3,000. I will say that you could do it for less money. And there are services out there, but what we always see is we're having to correct the work that these online services do. Anyone can file articles of organization. Not everyone can structure an operating agreement, taking your particular needs and requirements into account. So perhaps an initial outlay, but it really is just that initial outlay. And then the annual franchise tax board fee, which is $800, that will need to be paid every year whilst the LLC is in existence. You also need to pay for a tax return to be filed for the LLC. And then if your revenue is over, I believe it's $1 million, but I would direct you to the Secretary of State or the Franchise Tax Board's website. Depending on your gross receipts, you may need to pay an additional tax on top of that $800. I will say that for rental properties that do not generate a very large amount of income, we typically only see this $800 needing to be paid. The statement of information filing, I say it's a con, but it is really such a simple document to file, and you only need to do this once every 2 years in the case of an LLC. It's, of course, something that we can assist with if you ever need that. Loans may not be directly available to your LLC initially if you don't have, let's say, financial statements reflecting your ability to borrow. That being said, if there is real property that has been transferred in, you may find you have an easier time with the bank, and they will likely secure that loan with the property. And then lastly, you may need lender approval if you have a loan on the property and you want to then transfer it into your LLC. This is something to be very clear about. You should not go ahead and just transfer property into your LLC without facilitating this conversation with your lender beforehand.
Yeah, I look at the franchise tax board fee of $800 is kind of your insurance policy, because the benefit of having, if I have a rental property and I put it in an LLC and there's an electrical fire and people get hurt, the most they can sue me for are the assets in that LLC. So it gives a shield around that, and they can't get to my other assets. So yes, it's a huge amount every year, but it can be a great protection. And that's also where you need to look out for. We usually recommend the most conservative way is to put one rental property in each LLC, which, people start going, well, then I have this, cost every year. But if you put, if you have a $2 million property that you're renting with a small condo and something happens to the condo, now you're exposing the other property to those debts and liabilities. So by keeping them separate, you're shielding and only the assets in the LLC, which should be your rental property and then probably a small bank account where money comes in and out for the LLC. So you're protecting other properties you have, other cash or investments that you have as well. So in the end, it's a good thing for an insurance policy.
That leads into one versus several LLCs. What should you do if you have various rental properties? And Paula said it's always best advised to have a single piece of real property in a separate LLC. The question here is, what is your risk tolerance? And that's across the board. If you, let's say, have a residential property that you yourself live in, and you want to put that into an LLC along with a rental property, there is obviously a greater risk to both of those assets being under the one LLC umbrella. So quite correct. We always say if you can afford to pay the $800 across the board, it may be worthwhile place them all in separate LLCs. There are other items for consideration, such as transferring the property to the LLC. Paula and I were discussing earlier, and what I often see is clients who come to us who have formed LLCs with the purpose of holding their real property and then haven't been guided to actually transfer the property into the LLC itself. This is done by a deed to the LLC that would then be recorded with the requisite clerk recorder of the county in which the property is situated. And this is really the legal requirement in order to make sure that the LLC is the owner.
And doing that correctly, because you have to look, if I own a property and I put it into an LLC, I have the same basically ownership interest before and after, so my property tax doesn't change. But if I own 100% of the property and I put it into an LLC that Luna and I both own 50-50, now I've just made a gift to her, and it can trigger a change in ownership of the property and potentially change of property taxes. So you always have to make sure that when you're transferring it, are the owners proportional or not? And if not, are you aware of what changes are going to affect?
Then once your property is in fact in your LLC, the question is, do I ever need to inform any state agencies that there has been, let's say, a change in ownership of the LLC itself? And we really see this come in where you have multiple members of an LLC, so multiple owners of an LLC. There is a particular filing that gets made with the State Board of Equalization, and that is when there has been a transfer in ownership of over 50%. So basically, 50.1, or say it not just 50 on the dot, over 50%. You need to then inform the State Board of Equalization that there has been this change in ownership, and there is a requisite filing to do that. And lastly, insurance, 2 points here. We often get the question, how much insurance is enough? And I always say, I wish I had a crystal ball there. What can possibly happen on your property, right? So It's always important to work with a broker to determine what's best in your particular circumstances. And we, of course, can refer you to brokers here at the firm. And then on a second point, if you are transferring your property into an LLC, it is similarly important to speak to your broker about looking for a endorsement on your policy, naming the LLC or changing your insurance completely into the name of the LLC. Don't just leave it and assume that it will pay out. We need to take steps there as well.
Okay, great. And then putting your asset in a trust, whether it's held in an LLC or you just transfer it from your name or you and your spouse, putting it in a trust helps avoid probate and it allows for incapacity planning. So if I have my property in trust with my spouse and one of us is incapacitated, the other one as trustee has full authority to do what they need to do with the property, refinance it, sell it, rent it out, do whatever is necessary because the trustee is the one who's managing it. The same thing can happen upon death. If I pass away, then we do not have to go through probate if it's in a trust. My successor trustee then now has the authority to do what they need to do. So I'd say the only, con is finding the appropriate trustee. And sometimes that's a difficult thing, but finding someone who's going to follow what you're going to do and administer it if you are incapacitated or upon your passing. So as with everything, there are lots of properties or taxes involved. So some of the taxes involved, and there's a lot of confusion about this, is property taxes. And so first, property taxes in California are initially based on the assessed value, and that is usually the purchase price. So if I go out and buy a new home that's worth $1 million, I pay $1 million to purchase it. Generally, that is going to be my basis of my property taxes. And then it can increase every year. So we have what's called Prop 13 in California that says they're not allowed to increase your property tax more than 2% per year. So there could be differences. If I turn around and add an ADU, I add a second story to my property, that's a different thing because you've made significant improvements. But generally it's the 2%. And I know several clients have reached out in the last couple of weeks. At the end of June, Orange County started sending out their notices about that Prop 13 increase that's going to go into effect on their next, the bill that they're getting for December and next April. So keep an eye on that. And Prop 13 just is the limit. Your property tax can also go down. We had that happen a lot in 2008 when we had the real estate crisis, and it can go down, but then as soon as it starts going back up, the assessor will come back. And you can challenge it if you, if there's an increase that you think is more than it should be, then you're more than welcome to challenge it. But I'd say more often than not, we find out that the assessor's office has actually done a good job and come up with the appropriate value. But there's always those situations where it's definitely off. We've already talked a little bit about basis and capital gains. As we mentioned, your basis is what you pay for the property plus improvements. So it's very important if you're remodeling the house, putting a new roof in, putting a pool in, an ADU, to keep those receipts so that when you sell your property, it's the sales price minus your basis, which is the purchase plus improvements. Okay. So our example is, the house is worth 500,000. You pay your purchase price, you pay 75,000 for a pool. Keep the receipts. Your basis is now 575, and that will help you if you ever sell the property. And then, as we talked before, the basis does get adjusted to fair market value when the property owner dies. And we prefer it to be community property in California so that it doesn't matter which spouse dies, you get 100% basis step up. Or if it's a single person and owns it 100%, they will get, or as your separate property, you will get 100% basis step up. But if you own it jointly with someone, only the decedent's portion gets a basis adjustment, not the person who is still living. There's also, for capital gains purposes, if it's your residence and you've lived there 2 out of the last 5 years, then each owner can get $250,000 of the capital gain excluded. So for example, if this property is worth $1 million and I own it by myself, we take the $1 million minus the 575, which is 425,000. And then we're going to subtract 250,000. And then my capital gain is determined based on 175,000 of gain. And if you have a married couple, then it doubles, but it has to be your residence 2 out of the last 5 years. But it doesn't mean that it's not your residence for 2 years and then you rent it for the next 3. You just got to pay attention to the time frame so that you can take advantage of that capital gain exclusion. We've already talked about Prop 13. That's a big thing because of the increase. If there is what we call a change of ownership, then the property tax goes away, or we start with the new basis. So for example, I make a gift of the property to Luna, either at death or during life. That is considered a change of ownership. I sell it to a third party. Then the new buyer gets to take, or their property tax gets reassessed on their purchase price. They don't get to keep my purchase price or my property tax level, which is unfortunate, but that's how we pay for our roads and everything. And the change of ownership can be, a current interest. It could be sale, gift, bequest at death, and it resets it. There are some exclusions, such as when one spouse dies, then the property tax does not change if you're letting your spouse continue to use the property, or during divorce. So if one spouse keeps the property and the other spouse takes other assets, the deed is filed and we indicate that it's due to an incident of divorce and the property tax doesn't change. There are some limitations also for transfers between parent and child, or grandparent and grandchild, and that's where Prop 19 comes in. I'm going to talk about that a little bit on a different slide because that's a lot of different things that changed. We used to have the rule in California that if you transferred your residence from parent to child, your child got to keep your property tax basis, which was amazing because especially in Orange County, a lot of people bought their house for under $50,000. And these could be properties worth $1 million or more, and they have a very, very low property tax basis. But with Prop 19, that all changed. And then there's obviously the taxes that Luna talked about with regard to LLCs.
That's right. So just a reminder, that's your annual $800 franchise tax, any gross receipts tax that will be assessed by the Franchise Tax Board, and then any additional taxes once there has been this greater than 50% transfer, the reassessed value of the tax.
And that can happen. So say Luna owns 75% of the LLC and I own 25%. If Luna dies and we're the original owners, she transfers it to her son. Now 100% of the property in that LLC is going to get reassessed. I have no control over it, even though I'm still alive, because she owned more than 50% of that property. So it affects all the different owners. So those are things that are really important if you're going to be partners with other people. So going back to that Prop 19. So in November of 2020, the voters of California voted to basically eliminate the parent-child exclusion. It was significantly reduced. And so a lot of people get this confused. There's, like we talked about, Prop 13, they can only increase your property tax no more than 2% per year. Prop 19 relates to parent-child exclusion. So now, if a parent dies, if their child moves into their residence and makes it the child's personal residence within 1 year, there's a formula that we can escape $1 million of the appreciated value. So for example, the property basis was 200,000. Mom and dad bought it for that. It's now worth 1.5 million when they die. Their basis of 200,000 plus the next million of reassessed value, so up to 1.2 million, still gets to have a property tax level of 200,000. But we said our property is now worth 1.5 million. So the 1.5 minus the 1.2 is $300,000. So our property now will be reassessed at 300,000 plus the original 200,000. So although it's increased, it generally is still a good deal in that I'm only paying property taxes on a $500,000 level, and I have a $1.5 million property. So you are saving money in some instances. I have several clients where it's just not feasible, and their property may have significantly increased. And sometimes their kids have to sell the property because the amount of the property tax that they would have to pay is just outrageous. But remember, it has to be the child's personal residence. The child cannot turn it into a rental property. If that's the case, it doesn't work. And it has to be, they have to move in within 1 year. And then if they move and it's not their personal residence in the future, it gets reassessed again at that point. And there used to be the rule that up to $1 million of assessed value on all non-personal residents, like your rental property, commercial property, and things like that, was excluded from change as well, but that got completely eliminated. So if you have a second home, a rental, commercial property, those will be completely reassessed when you pass away, regardless of who you're transferring them to. And even if your child sells it, you know, say 6 months after you pass away, they will get a supplemental tax bill for that 6-month period where the property tax is increased. Prop 19 did add some benefits to those who are 55 years and older, that they can transfer their property tax basis to a new property in California up to 3 times, which is very helpful if, for example, you bought a house in Anaheim and your property tax basis is $500,000 and you want to move, you know, up to Ventura to live with your child. You can buy a new property up there if the value is equal or less than the fair market value of your current property. You get to keep your same property tax basis, which is wonderful. So it allows you to perhaps downsize or move closer to children and things like that, as long as you're doing it within California. And you can do it up to 3 times. If the property that you buy is above the fair market value of your current property, there's a formula to figure out a portion of it. So you do get a bit of a benefit. And this is an increase because it used to be just 1 time you could move and only into certain counties. So now it's all over California and 3 times if you need to do those things. And then there's some LLC fun that we can do with it. Do you want to talk about that, Lina?
No, if you wouldn't mind taking
Okay.
that, Paula.
So sometimes in estate planning, we are using LLCs to work around some of the reassessed value. Because as we talked about, if you put the property into an LLC, mom and dad put the property into an LLC. They are the original owners of the property. They are the original owners of the LLC. And as Luna mentioned, you can transfer up to 50% of that without it being subject to reassessment. So let's say mom and dad put a rental property in the LLC. They transfer 50% of that to their daughter, 50% of the LLC. There is no change in property taxes. Then what they do is they turn around and maybe a couple years later, terminate that LLC and would pull out the property. Now mom and dad own the property 50%, daughter owns the property 50%. We've transferred 50% ownership in a piece of real estate and did not have a property tax change. So you have to take it out of the LLC at a future date, because otherwise then you will get to the point where you have more than 50% has changed from the original owners. Now the daughter and the parents can create another LLC. And this is a difference because now the 3 of them are the new owners, original owners of the LLC. So then when mom and dad die, they're going to transfer 50% to the daughter. And in this scenario, this new LLC, they are the original owners and we have not transferred 50%. So there's ways to get around it, but it's usually done over multiple years and in certain situations. So if those are areas, then we can look at those. Obviously, there's the pros being the property taxes. The cons are because that property has been transferred, at least the initial 50% during lifetime, that property does not get a new basis adjustment. So you're kind of having to trade on, is it better for me to not have a property tax increase as long as I own this property, or a capital gains tax because I didn't get the basis adjusted, or I did get the basis adjusted. And those are all factors on if it's property that intends to be kept. You know, if the child is planning on keeping this commercial property that has a great income stream and they plan on keeping it for the rest of their life, You may not want to have a property tax increase of $40,000 per year for the rest of their life. You may want to have it delayed, and then deal with capital gains tax in the future if the property is ever sold. So if that's a situation that you're looking at, we can go run through different scenarios on what is appropriate or not. Then there's a lot of different ways to transfer your real estate when you die. So the first thing is intestate succession. And that basically means you don't do anything while you're alive. And when you die, it goes through probate. And the state of California has created an estate plan for you, basically saying the assets go to your heirs at law. And that differs between if you're married, if you're not, if you have, are you married with one child, married with two children, if it's your separate property, if it's your community property, and things like that. The downsides of the intestate is obviously it's probate. I mean, sometimes it could take 4 to 5 months to even just get appointed as the person, the administrator in charge of the estate. So the question becomes, who's paying the property taxes? Who's collecting the rents? Who's doing repairs on the properties? Nobody really has authority during that time. So it could become an issue. Or the issue that if the intent was that maybe one of your children have the property and your other children have other assets, going through intestate succession could eliminate those issues if there's not enough assets to divide. You can transfer property, as we discussed, via joint tenancy, where the surviving joint tenant or tenants automatically receive the property. And it's all it is you file a document. If we have a deed, if Luna and I buy a property and it's Luna and Paula as joint tenants, if I die, she files a document called an affidavit death of joint tenant, and she owns it 100%. Court's not involved or anything. It's very easy. Similar thing with community property with right of survivorship. Very easy to transfer at death. But as we discussed, there's a lot of other issues during life that could put limitations on it, as well as what do you do with the surviving joint tenant or the surviving spouse? Now, when they die, the assets are going to go through probate unless they're put in a trust. We do have a new law that came into effect in April where it's called a small estate. And in California, if you have an estate under general estate under 208,500, you can avoid probate. You know, we use this a lot for, let's say, college students and different things like that. Say you have, you know, a young adult that maybe has a 401k and $10,000 in their bank account. If they were to pass, we don't have to go through probate on that because it's under the $208,000 limit. But if you own real estate in California, you're almost always over that. And in April, they extended it, the small estate affidavit, to say, if it's your primary residence and it's valued at less than $750,000, we can avoid a full probate. Now, you still have to file documents with the probate court and go through that and list the heirs so that it can be sold and divided. But you don't have to necessarily go through the full probate process of giving notice to creditors and things. So the idea is that it's supposed to shorten the time for the property, make it fair so that all the beneficiaries are aware of it. We haven't really seen it played out yet. Us estate planners are a little bit leery of that. I guess, first of all, is there really any much property under 750,000 in Southern California? Usually not too much on a primary residence, at least in Orange County. There might be some raw land or things like that that people own. But it's going to take some time to see if this is going to work. It's supposed to be better, but time will tell, and if there's going to be ultimate changes to that in the future. California also has a process called a transfer on death deed. So this is only for your personal residence. It cannot be used on your commercial property. For example, if I have one child, I can file a transfer on death deed that says when I die, the property goes to my child. And then when I die, my child then files documents to get that with a recorder, and no probate is necessary. This is a revocable deed, so you could always change it if you wanted to, but it has very strict execution requirements. It must be signed, notarized, and unlike regular deeds, it has to be witnessed by 2 impartial adults and then recorded within 60 days. So a little bit more restrictions than just filing a regular deed. And just like joint tenancy and things, it will pass appropriately and very easily at death. But again, we don't have the precautions that what happens if the parent becomes incapacitated and they need to go to assisted living. The child doesn't have authority to rent out the property. The child doesn't have authority to get a reverse mortgage on the property or sell it to be able to take care of their parent during life. So that's why we usually recommend the trust to provide for those scenarios. If you just have a will in California, it's very similar to intestate succession where you're going through formal probate, except the will allows you to name who your beneficiaries are as well as your executor, but you're still going through the full probate process. So we think the best way to avoid it is to put your assets, whether it's your residence, your property that you own directly, or as Luna said, your LLC into your trust. So your house goes into the LLC, your LLC owner is the trust. And that way, upon your incapacity or death, you have already detailed in your trust document, these are the people who are managing it. This is what I allow them to do. These are the beneficiaries. And you keep that privacy and cost down by not involving the court in the process. Obviously, there's some restrictions available to beneficiaries too. You could put that, for example, my boyfriend is allowed to live in the house for 6 months, or whatever it is, after I pass away, or a friend is, or somebody like that. So you can put a lot of different things on it, because you could see that if you left it all to maybe your children and it was a second marriage, that they may want to cut out your spouse very quickly, or your significant other that may be living there. So you can accommodate all these different situations within your trust, so that the family is taken care of and those situations are addressed.
I'll just jump in on the LLC side there quickly, Paula, is especially in situations where you have more than one owner. So let's just say you own a piece of real property with your brother, and it's in an LLC, right? So you're 50-50 owners. What we can really do in an operating agreement, which is the governing document of an LLC, is we can set the terms of what needs to happen to that piece of real property owned by the LLC upon death of one of the siblings. We see situations where, let's say, the brother does not want to deal with the spouse of the sister upon her death. And a way to facilitate this changeover is really to make sure that we have drafted correctly when we are looking at the operating agreement. So I would say in less straightforward situations where you are dealing with multiple owners or difficult family relationships, and you're asking yourself the question, well, do I really want to be in business with this person after my other member dies or passes away, sorry, we can definitely take a look at the operating agreement and say, okay, well, what would you ideally like to see happen? And let's draft to bring that forth upon your death or disability.
Okay. So that concludes our presentation. We're happy to answer any questions that you have now, or if you want to reach out to us separately and talk about your specific situations. I do see a question about parents co-signing and helping their kids buy a house. This ends up being a problem sometimes, because every parent that has come in and said, oh, I helped my son or daughter buy a house and I have co-signed, they are put on the property as an owner. So they're not just co-signing for the mortgage, they end up becoming a joint owner on the property. So that's always very careful to consider, because now if the parents own part of the property and they die, the property tax is going to be increased. So you have to look at those situations, make sure that if you're helping out any family members, should it be done via loan versus a co-signing? How is ownership going to be taken care of? Are you filing gift tax returns? There's a lot of different aspects of it, and looking at the deed is going to be very, very important.
I'll just speak to a question that I often receive, and that is, how do I know whether my property has been correctly placed in an LLC. So these records are reflected on the county recorder's index. And I would say just reach out to us so that we can do a search of that index through a third party that we utilize, and we can make sure that it is in fact deeded to the LLC correctly and it's been done correctly. And in a similar vein, I get a question, well, how do I know if my interests have been assigned to my trust correctly? Now, we have to do this with the governing of the operating agreement, telling us how we can assign those interests, and then draft the requisite documents to, one, assign correctly, and two, update the operating agreement. So in a similar vein, if you have any questions or are concerned that you've set up these vehicles, but you're not sure if you've really followed through and you are truly as protected as you thought you were, please don't hesitate to reach out to us.
Yes, we'll always help you. And we have our clients that end up buying properties after we've created their trust. We'll be happy to help you deed them in. We can take care of that so it's done correctly for you. Well, I don't see any more questions. So like I said, if you think of something later, you're free to reach out to Luna or myself. And we have our next webinar for estate planning on August 20th. We're talking about tax moves to make before the year end. There was a big bill that was passed, and now we can pass $15 million per person estate tax-free beginning January. And that is supposed to be permanent, and everything's permanent until Congress changes it. So at least though we don't have a sunset like we did before, we have a bit more certainty. And then our next employment law webinar is going to be in September. They're taking August off. So keep an eye out for emails and our newsletter with details on those forthcoming. So thank you very much for attending, and we look forward to seeing you soon. Bye-bye.
Thank you so much.